The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Monday, the 25th of April, 2016, are currently trading with gold at $1,237.77 an ounce, silver $16.97 an ounce, Texas crude $43.73 a barrel, and Bitcoin is currently at about 471 U.S. currency. Today in history, the year 1846, the Thornton Affair, also known as the Thornton Skirmish, Thornton's defeat, or Rancho Garicitos, was a battle between the military forces of the United States and Mexico along the Rio Grande. The Mexican forces defeated the Americans in the opening of the hostilities and was the primary justification for U.S. President James Polk's call to Congress to declare war, the beginning of the Mexican-American War. Today in history. In recent news, the U.S. is ranked 41 out of 180 countries in the Reporters Without Borders World Press Freedom Index, though the organization notes that the U.S. has moved from 49th in 2015 to 41st this year. However, the U.S. government's war on whistleblowers and the country's lack of a shield law, which would allow journalists to protect confidential sources, does maintain a negative view of U.S. press freedom. Obama's Justice Department has cracked down on reporters in an effort to prevent leaks. It has also set a new record for withholding access to government files under the Freedom of Information Act, despite his calling for a new era of openness on the first day of office. And photojournalists in 2013 from several major news organizations criticized the Obama administration for denying their right to photograph or videotape the president while he was performing his official duties. Finland, the Netherlands, Norway, and Denmark all ranked in the top 4 spots, while Syria, Turkmenistan, North Korea, and Eritrea are in the last 4. 2 Swiss pilots, Bernard Piccard and André Burchard, are taking turns flying a solar-powered airplane around the world. The plane, the Solar Impulse 2, took off from Dubai, the capital of the United Arab Emirates, in March of 2015. It made stops in Oman, Myanmar, China, Japan, and Hawaii. The aircraft did encounter a few turbulences along the way. It had to land in Hawaii in July and was forced to stay on the island after the plane's battery system sustained heat damages on its trip from Japan. The team was delayed in Asia as well when attempting to fly from Nanjing, China, due to unfavorable weather and a damaged wing. A whole month later, when better weather conditions arose, the plane left Nagoya in central Japan for Hawaii. Solar Impulse 2 will make 3 more stops in the United States before crossing the Atlantic Ocean to Europe or Northern Africa, according to the website documenting the epic journey. This is Rick Brody with your lowdown for April 25th, 2016.
Say somebody been shot, somebody's been abused, somebody blew up a building, somebody stole a car, somebody got away, somebody didn't get too far, yeah, they didn't get too far.
Grandpappy told my pappy back in my day, son, a man had to answer for the wicked that he done. Take all the rope in Texas, find a tall oak tree, round up all of them bad boys, hang 'em high in the street, for all the people to see.
That justice is the one thing you should always find. You gotta saddle up your boys, you've gotta draw a hard line.
When the gun smoke settles, we'll sing a victory tune, and we'll all meet back at the local saloon.
We'll raise up our glasses against evil forces, singing whiskey for my men, beer for my horses. We got too many gangsters doing dirty deeds,
too much corruption and crime in the streets.
It's time the long arm of the law put a few more in the ground.
All right, folks, good evening. This is the Monday Night Rule of Law radio show on April 25th, 2016 with your host, Eddie Craig. For those of you that are listening, thank you so much for doing so. And for those of you that have been helping support the network and me personally with donations and stuff to keep us on the air and going, we also thank you. I have been getting some information on the GoFundMe site account. It seems like the reason, if you've been told that you can't make a donation right now, for some reason, they have not registered the information for the bank account that we've hooked it up to. I'm trying to figure out what to do about that. I've sent them an email and everything saying, hey, we did set this up, but we're still getting told that nobody's getting it, and we can't figure out why, because the account information has been set up already. So if you've had a trouble with that, please don't give up trying. Just keep going back and trying again. There's something wrong with it. We just don't know what it is yet. So please bear in mind that, we're trying to get that done. We really could use that money to fund this lawsuit and make this fly. All right. Now, what we did in class yesterday, as you remember, a couple of weeks ago, I told you about a video that I did for the class where I was talking about the one and only written rebuttal to the constitutional challenge motion that we have had, and that it was written by a completely incompetent city attorney in Williamson County. Now, I decided that video was overboard for public consumption, even by my undertake, because I was mad that day that somebody could be that openly and brazenly stupid and still be given a law degree. I was mad that day. So yesterday, I redid all of that. I went into a more detailed discussion over the constitutional passing of the bill, unconstitutional passing of the bill, and went through line by line rebutting her assertions and arguments in relation to that specific area of the motion itself. Now, as I've told you before, the motion is divided up into three specific areas. It is the unconstitutional enactment, it is the unconstitutional interpretation by the courts, and it is the unconstitutional application by everyone to the general public, rather than only to those that are engaging in the occupation that the subject is of that's being regulated, okay? It regulates an occupation. Everything in that code applies only to someone in that occupation, engaging in that occupation, and that is not the general public. Now, that, of course, would be true if the whole code was not unconstitutional on its face. But yesterday's class, I think, went fairly well in going through that step by step and line by line and showing you exactly how incompetent these attorneys really are. They want you to think that they understand the law, that they know the law, that they know how to argue it, that they understand things that you don't. That's a farce, okay? It's not true. This woman's written paperwork is proof positive it's not true. And I just finished doing the encoding for one video camera's stuff, and I've got to do the encoding for the other, and then I've got to merge the two if I do that. But and then I'm going to get it uploaded onto YouTube. I'm going to link it into my blog site, Tao of Law, TAOOFLAW.wordpress.com. And I'll also link the YouTube link back into the Facebook page. And I'm getting messages up right now asking if the show tonight is live or if it's a recording. It is live, people, April 25th, 2016. That would be today, right? All right? We're not a recording today. We're live, so keep that in mind. And we are going to be taking phone calls here in just a minute. I had several people from the Facebook page and from around show up in class yesterday, and that's good. But, folks, the class is still not anywhere near the size it should be for what we're fighting against. Do you folks really understand what I'm trying to do here and what it would mean to you to support it by coming to the class and learning how to fight back against what's being done to you, your family, your neighbors? Do you really understand that? Because what I'm going after here is their stepping stone to everything. They use this code to do more harm to Americans in every state than anything else, because they use it to fabricate every false stop they make. They use it to fabricate probable cause to conduct illegal searches, warrantless arrest, seizures of property in every state. You understand that, right? Without this stepping stone, their ability to do those things is greatly lessened. It is time for us to recognize where they're beginning this and put a stop to it. And that's what I'm trying to do. This is not about me and my desire to not follow the rules, okay? It is my desire to get you to understand that there aren't any such rules and that there never could be when it comes to you and I acting in our private capacities as free individuals. It's an oxymoron to believe that you are free and at the same time bound by every dictate from everybody that goes into a public office and tells you, now that I'm here, you have to do everything I tell you, whether you like it or not, whether it's constitutional or not, whether it's moral or not. Because if you believe that, then you're not free at all. And that's the part you've got to overcome. Now, that being said, I want to go ahead and start taking calls early on tonight. I've got several people up on the board already. And our first caller is Max in Texas. Max, what can we do for you? And I know what we can do for you. I asked you to call in because you came to class yesterday, and you brought friends with you. And I asked you to call in to let folks know that was also your first class, correct?
Yep, that was my first class.
Okay. So what I would really like is for you to tell people honestly, without any impetus from me, what you thought of the class and the information that was in it.
Well, I love the interaction. First of all, when we're in a live setting like that, there's no suppressor. So, being able to go back and forth in conversation is relatively easy. And I was impressed that you didn't even need a microphone for that venue. You must have quite a set of pipes there. But I was kind of surprised that there weren't that many people there. I was expecting that more people would be engaged in this fight.
You and me both, brother. You and me both, especially with the number of emails and phone calls I get. Help me. And how many of them are in Austin and still never show up for the class?
Yeah, and even with my yellow belt, maybe even in this fight, I get several requests. Everyone I know is asking me about their traffic tickets, and I just have to kind of explain to them, look, guys, you better be ready for this fight before the fight comes. So you got to kind of look into this stuff before you even know that it's germane or important, and that's how you're going to win it. And I really liked that you were focusing on the constitutional challenge that you've made, because that is the Achilles heel, like you said. That is the tip of the spear. It's such an easy argument that anybody who can read, except for these lawyers apparently, can clearly see that they've used an illegal emergency clause, and so the whole thing's invalid. And if we can get this victory or support Eddie getting this victory, everybody needs to do it.
Well, I appreciate that input, and yeah. That's what I'm trying to get you to understand, folks. This benefits everyone. Everyone. This sets precedent in Texas for the entire state. Not just Austin, not just Eddie. Everybody, everywhere in Texas. This puts a whole new spin on what's on the drawing board. I'm sorry, go ahead, Max.
Yeah, if I may, Eddie, if we can continue at the classes and, on the Facebook group, sharing the idiotic responses that these lawyers have to this obvious argument, then we can keep bolstering our the constitutional challenge motion to completely, hammer all these leaks shut, and the supposed leaks anyway.
Absolutely. And it also allows us to practice a specific verbal rebuttal on the fly if we need it. Because, like I said, I went through the case law that this female attorney used in her idiotic rebuttal, and it does not support her position. In fact, it completely undermines her position when you read what the case actually says. So this is what you have to understand about these attorneys. They count on your ignorance and inexperience. They know that you don't know how, or even most of the time have the capability to go look up a case that they cite. And then if you read it, you may not understand what you're reading, because sometimes the opinion is written with a nuance rather than straightforward language to let them basically make an undercurrent for you to understand what they are really saying without actually saying it. And this is lawyer speak intentionally. This is how they hide what they do from the eyes of the public to make themselves look absolutely necessary.
Yep, and they think that we're not going to understand or be too lazy to look up a site that they make in their rebuttals or in their answers. And that's just I don't think that's the case for a lot of the people that I've run into out there. That they're not too lazy to look up these case laws and see if they're on point. And the subtlety of the way these rulings read makes it even clearer to understand that they're not on point.
Yeah, exactly. All right, Max, I got a break. Can you hang on just a minute if you got anything else, and we'll finish it on the other side?
Okay, yeah.
All right, folks, this is Rule of Law Radio with your host, Eddie Craig. The call-in number is 512-646-1984. If you got a question, query, poser, comment, or issue, please give us a call, get in line, and we'll see what we can do for you in the time we got left.
Now.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Look what we got. We asked the question. Wonder what I don't have the answer. We asked the question. Look what we got. And they don't have the answer. Slip and slide.
right, folks, we are back. This is Rule of Law Radio. Call in number 512-646-1984, and we are talking with Max in Texas. All right, Max, go ahead, please.
Yeah, I really didn't have a personal issue at the moment, but I did want to, say to anybody else who's in the Houston area, if we, if you want to get together and carpool and go up there on Sundays and attend the class, I had to leave approximately by 11, and so a good 2 hours and 45 minutes to get there, and so I had a little bit of time to park and get there to the Brave New bookstore, and if anybody else wants to go, I think all of us, and I know there's a bunch of us, Josh and Bob, Michael, I think, if we can all coalesce around this constitutional challenge and refine it by bouncing, off each other's, the cases and answers that the people that we're getting, I think that we can really maybe hammer it and make these people really tired of this argument until they do something about it.
Well, what I'd rather they do is recognize they never had the authority to do what they're doing in the first place, and that now they're liable for everything they have done through fraud. That's what I want them to recognize. But in order to make that happen, we've got to get the people here in Texas to recognize that their public servants are a bunch of criminal thieves and liars. And so
it just seems to me that the constitutional challenge is so cut and dry and easy to understand. There's no abstract rabbit trails to track down. It's just, it says it's supposed to be this, it's not that. They said it's not that. That's it. What else is there?
Yeah, you would think when it's written in black and white, there wouldn't be this ability to completely misinterpret something like the word all to mean anything other than exactly what it says. In fact, I read a case today on a foreclosure where a bank was asking the court to ignore the word all and interpret it as some. And the court said, you're asking us to throw away the common meaning of the word. Not going to happen. But that's exactly what this attorney did in her rebuttal with several things, which hopefully I made clear in the class yesterday.
Yeah, you made it abundantly clear. And I must say, watching you live, you're a lot more animated, and you can see your gestures as opposed to just imply them. And
no, he doesn't mean those kinds of gestures, folks.
No, not those kind of gestures, but definitely, and the the ability to be able to get angry and drop an F-bomb every now and then. It's a little bit of a different experience than catching it on the radio.
True, I do kind of have to clean it up language-wise here, and I know not everybody appreciates language for what it is, but folks, you have to remember, words are just somebody's interpretation of a thought. If I told you to go shove a pickle up your nose, but I said it with the same intent that I would drop the F-bomb you on somebody, then what would be the difference between the two? You see what I mean? It's just simply your interpretation of the words that make the difference, not the words themselves. So just because of language or something like that, that's not really a reason to not learn. That's not really a reason to not come to class. Because believe me, if you went through what I went through trying to get people to understand what, to me, should be pretty simple concepts, and every single day, just to watch them go out and hang themselves anyway, or you watch these criminals lie to people's face about how things apply and how they work, you'd want to be dropping F-bombs here and there too. Believe me. I mean, for instance, and Max, is there anything else you want to say before I get on this part of it here?
Just one other thing. I'd like a copy of that attorney's rebuttal.
Yeah, if you've got the constitutional challenge motion already, I'm going to post her rebuttal up on the blog site so everyone can get it, regardless of whether you have the motion or not. But her rebuttal will not make nearly as much sense until you've read the arguments that I put against them that she's trying to rebut and failing miserably to do so. But even with her citing the same sections of the Constitution that I did in my argument, she shoots her own argument right between the eyes so many times it's a public execution of her own argument. I mean, it's ridiculous how inept she did this. And I'm going to make a point of making her famous in her office because I'm sending the link to this video to her boss.
I can't wait, brother. I'll be hanging out, and I'll be listening in the background.
All right. Thanks for calling in, Max.
Thanks, Eddie.
All right, now real quick, what I was going to get to is this. We were having a discussion on Facebook, and this is what I'm talking about with people either A, not wanting to understand, B, not listening so as to understand, or C, deciding that no matter what you tell them, it is a pointless conversation, which you're just wasting your breath engaging in anyway, because they're not going to get it. They don't want to get it. They can't get it. at that point, it doesn't matter which one it is. The fact is, your time is being wasted. Now, in this particular discussion, this gentleman is being charged with a rather serious offense. Cruelty to animal, i.e., specifically the charge of torturing an animal. Now, based upon the facts that he presented, there is no torture that was intended here. And under the statute in Texas for that act, intent to commit torture is an element of the offense. You must have specifically wanted to inflict that cruel harm, that pain, that suffering, and then engaged in the acts to perpetrate that harm. That's the requirements, elementally speaking, under the torture statute when it comes to animal cruelty. Now, in this discussion, we are trying to get this gentleman to understand that his affirmative defense is to simply rebut the concept of intent. Because the facts, according to what he gave us, and without being there, I'm going to accept those facts as true without contradicting evidence, is that he had a dog that he found and had been raising and with his family and everything, but he didn't know the background of the dog. Well, the dog became aggressive and attacked his little girl. He took the dog out back and attempted to put it down with a shot to the head. Well, the dog dropped, but it didn't die. And within some length of time, that area is kind of gray, but within some length of time after being shot in the head, the dog was found scratching and alive at the back door wanting to come back home. Well, the guy then took the dog out and attempted to shoot it again to put it out of whatever suffering it might be undergoing, but at the same time to complete the original intended act of putting the dog down for attacking his daughter. Apparently, 2 more shots, and the animal still would not die. So either A, the guy's using way too small a caliber of gun on the type of dog he's trying to execute, and that's just basically what he's doing. He's attempting to execute a bad dog because he can't afford the exorbitant amount of money that the veterinarian wants to put the dog down. And I can't blame him for not wanting to spend that either when it's just as simple to do it with a gun. But that's not a here nor there. As far as the facts of the case go, 3 shots, the dog still won't die. So the district attorney in the area is attempting to charge him with torture because he shot the dog 3 times and it didn't die. His affirmative defense here is, A, yes, I shot the dog. Yes, I shot the dog 3 times. However, there was never any intent to cause pain and suffering, as the location and type of shots clearly indicate. Therefore, there was no intent to torture. That's an affirmative defense to that specific element of that charge. And remember, they must have all of the elements in order to successfully prosecute. If they don't have even 1 out of 3 or 5 or 10 or however many there are, if they lose even 1 element, that charge is dead in the water. Intent to commit the cruel suffering is an actual element of the torture charge. That's all he has to rebut is that intent. And the guy could not get this concept. Tried, and it wouldn't sink in. So, folks, you don't know what you think you know, and you need to learn it. Y'all hang on. We'll be right back after the break and take some more callers.
Get out a hat and sunglasses. In San Diego, law enforcement agents are using video surveillance cameras and facial recognition to pick faces out of crowds. I'm Dr. Catherine Albrecht, back with details in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Privacy-invading technologies are coming online faster than you can scream Big Brother, and one California company called Face First tops my spooky list. Face First has developed scanners that can sweep a crowd from 100 feet away to record every face and feed those images into a database. People are identified in under a second. Already deployed in Panama, Face First is now being tested on San Diego streets. Imagine the feds, drones, marketers, and stalkers all scanning our faces and identifying us as we walk down the street. Yikes, I'm buying a floppy hat and some sunglasses. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Live Free Speech Radio, LogosRadioNetwork.com.
Yeah, I got a warrant. And I'm going to serve them to the head government, them. Prosecute them. Okay. Oh, sir. Citizens arrest for Mr. Bush. Citizens arrest for Dick Cheney. Well, I need a prosecutor to come and help me. Prosecute them wicked leader, you see.
All right, folks, we are back. This is the Monday Night Rule of Law radio show. We'll call in number 512-646-1984. And now we have JD in Texas. JD, what can we do for you?
Hey, Eddie, I just want to talk about basically like a continuation of what Max was saying. I was there in class yesterday, and, you know, I've been there, 3 times? I think it's my 3rd class I've been there. And I was actually surprised, too, that it seems like every time I've gone, the number of people have declined. Now, when you see, I follow you on Facebook, and you and I have talked quite a bit and everything, and I see all these different things where people constantly are sending in questions and this and whatever. It's like, everybody seems to be, I guess, excuse my language, I'm not I'm trying to be clean here, but everybody seems to be pissed off about what's going on, but nobody seems to really want to go and learn what it takes to fight against this corruption. And I understand it's not always easy. I'm not far away, but I can't make it all the time either, but I get there when I can. And I know there's got to be people that are just right there that can do it. But, and folks, I want to say that being in class with Eddie, like Max said, is a whole different situation. You can hear all the stuff on the radio. You can read all the stuff on Facebook, all his posts, whatever. But I remember, Eddie, that time that I guess maybe the first, second time I was in class, you basically had pulled me up onto the stage and did a mock interrogation of me as if I was in a courtroom. And basically, I remember your words were, if you could survive what I'm telling you now, what I'm doing to you now, you can survive them in court. And then last night, you said the same thing, basically, that you've got to learn how to answer this because you've got to answer it in court. And if you're going to try to fight this fight, you're going to learn this stuff. I read into the seminar material all the time. I'm constantly into it. I think I have a pretty good grasp on it. But when you go to the class and then you turn and ask a question, and I know the answer, but I can't be quick enough to, like, you got to be fast to be able to reply in court. Well, you do the same thing to it, and then that experience is invaluable because if you're not in trouble at the time, but you get that practice, that is invaluable.
Absolutely. I mean, when I ask you a question in class and I get you up there on the stage and do one of those mock interrogations on the witness stand, I'm going to be as mean and as obnoxious and as scary to you as I can possibly be. I'm going to do my best to make you feel foolish, look small, and feel bad. And the reason for that is very simple. It's not because I want you to take it personally. It's because this is what you're going to face in the court. That's exactly what that prosecutor is going to attempt to do to you if you're getting the upper hand for any reason. It's what they may do to you if they feel like you're too weak to defend yourself in any way. Right. So if you can face me, they're going to be easy because I can say things to you that they can't in a courtroom in my classroom. And that's the whole point, folks.
Yeah, I think a lot of times people hear, and I think I've made comments about it before. I think I just called in to the show and said something like this before, that a lot of times you do get a little bit irritable. Oh, my God, how many times can you tell somebody the same thing but not listening to? I can see the irritability. But a lot of times it's just a matter of fact that you just have to get in their face and prepare them. And I think that sometimes people just don't grasp that tough, let me say it I'll say it like this, that tough love. That tough love where you've got to get through, just like you get to your kids in a certain way, get through to people in a certain way, but you're doing it in a way that makes them realize, I have to man up to do this. But it's not just being tough and this, it's like, it's all got a systematic process to it, and it's all backed up with law. And so, Eddie, I thank you, everything you've ever done, and but for all the people out there who want to fight this corruption, I just say get to the class. So, Eddie, that's really all I got, man.
Well, I appreciate it. And like I say, you're right. I do what I do for a reason. And I had my call screener tell me the other day that he was telling some folks about me who actually went and listened to me. And I don't know in what context they listened. I don't know if they listened to a show that I was doing at the time, to a podcast, to a video on YouTube. I don't know. But the feedback I got was they told him that they thought I sounded like an a-hole. Okay. What do you want me to do about how your interpretation of what I'm trying to do is? You're free to have that opinion. I can't change that opinion. But again, most of the people that come up with that opinion, from my experience, are in one of two places. They either, A, don't accept that there's something wrong and they think everything is hunky-dory the way it is, or B, they are doing things that are not proper and actually going to help them, but you cannot change their mind about them regardless. And that's the ones I refer to as the patronuts that will do everything in their power to look like a UFO snatch job reject on the evening news in a courtroom rather than do everything they do themselves and do it better and win. I don't understand. Okay?
Well, I can see these kind of people being the ones that as soon as the judge or the prosecutor kind of gets onto them, they just kind of ball up and cry out.
Exactly, and then come out and complain about how they got railroaded, how it wasn't fair, and they didn't even get a chance to defend themselves. Newsflash, folks, they're not going to give you a chance to defend yourself. You're going to have to take it.
That's right.
And I sound the way I do, and I talk the way I do, and I express myself the way I do because I used to be you. And I'm not going back there again because I know what it cost me to be there. I know what it's costing me to be where I'm at, but at least I can hold my head up and say, you're not going to walk on me for free.
Amen, brother.
You walk on me, you're going to leave with bitten ankles and bloody feet, period. So take that as you will, folks. If you think that's what I sound like and that's how your impression of me is going to make it everlasting, well, okay, that's fine. But that shouldn't stop you from understanding that what I'm trying to give you is real, valuable information, useful information. Whether you like my method of delivery and teaching it or not, that's a fact. It's information you don't currently have and you absolutely don't know how to use. And I'm trying to prepare you for both. So take that as you will. There's nothing I can do about people's impression of me. I've changed my attitude about things in my life several times to please other people. It's never worked out. So I'm sticking with where I'm at. At least this way I feel good about me. And a lot of people are confusing confidence and knowledge with arrogance and, just belittling of other people. And that's not true. I speak with authority because I know I'm right. I've spent too much time studying it, researching, and understanding it to not believe I'm right. It won't do me any good to go in court and speak as if I'm guessing or that I'm not sure. If I don't go in there and speak like I know what I'm saying and why I'm saying it, it's not going to do me any good. It's not going to do you any good either. That's why this attorney in this rebuttal motion she wrote speaks with confidence, even though her facts can be proven to be completely ignorant and incompetent. She still wants to be believed, even when she's dead wrong. And that's just the way it is. All right, JD, sorry, I didn't mean to rant in your ear there, but anything else, man?
No, man, you're good. You're good. I just want to say, y'all get behind Eddie. Y'all support it. Y'all get to the class. Y'all learn all you can because Eddie rocks. Y'all got to get on board. Eddie, I appreciate you. We'll talk later, man.
All right, JD, thanks for calling in. All right, folks, this is Rule of Law Radio. Call in number 512-646-1984. Mark, Charles, and Ernest, I'll see you on the board. If y'all hang on, I'll be getting with y'all through the rest of the time we got. So y'all stay right there.
Not wage any battle, would your purpose have be done? Such a sentimental soldier, a warrior of love, scalpel and to keep the peace. All it taken is a misunderstanding. If somebody calls the police, watch the spotlight.
All right, folks, we are back. Call in number 512-646-1984 if you want to call and get in line. Right now, we are going to talk to Mark in Texas. Mark, what can we do for you?
Yes, sir. Unfortunately, I've got a personal problem.
Well, when you say that, you do mean personal legal, right?
Yes.
Okay. Just want to make sure. There's certain things I just don't do here, man.
Oh, okay. I was stopped by the Carrollton Police, 2014, December 28th. It was all right. They pulled me over for DWI, but when they pulled me over, all right, the video of them pulling me over, the guys were both at a stoplight, and he's got it all on video. I pull forward. I couldn't be going over 20 miles an hour the whole time. I signal to change the lane. And then about 100 yards into it, he puts his lights on. And I pull over, and bottom line is they took a blood test, and my blood turned out 0.096 or 16 thousandths over.
Yeah, 0.08 is the legal limit. Okay, well, let me ask you a question based upon what you've said so far. You said you were going 20 miles an hour and remembered to use your turn signal when you changed lanes, correct?
Yes.
Okay, when you're going 20 miles an hour, was the street you owned by any chance marked for faster than that?
It was under construction. There were construction barricades.
Wait. That's not my question. My question is, what was the speed limit actually?
35.
35. So you're 15 miles an hour below the speed limit, even in a construction zone, right? What time was this?
Go that fast.
Wait a minute. What time?
It was 12:30
a.m.
a.m.
Okay. Well, then you did the one thing that most people that are caught behind the wheel under the influence tend to do. They tend to slow their car way down. That is almost a universal training signal to a cop that if you're going that far below the posted speed limit at that time of night, then odds are you're dealing with someone under the influence. Now, I understand the reason why you did it. Don't get me wrong. And I'm not saying you did a bad thing by doing that. But you got to understand that that's a red flag to a cop. That time of night, coming from the direction that you must have been coming in, where they knew there's probably a bar, or at least some place that served alcohol.
From my house, I was going over to girlfriend's.
Okay, well, either way, going that fast, in that manner, at that time of night, that's going to be a red flag indicator to a cop for a DUI. And you have to remember that they can fabricate a traffic stop for anything. They can make it up. And the only way to beat it is to get video from before the time they stopped you that clearly shows that their basis was a lie and that they never had articulable probable cause or reasonable suspicion. They didn't have anything. They just stopped you anyway, which they can't do. So they fabricate something. What did they tell you when they came up to your car?
He told me I was speeding.
Speeding at 20 in a 35.
Yeah, I'll show you the video. I got copies of the video. Your meeting's in Austin, right?
Yes. Okay, well, what is in this video that's going to prove your side of the story is my first question. You say you've watched it. What's in it that proves your side of the story?
Well, I was going slow, but...
Okay, not the full correct answer. Going slow is relative.
Okay, I was stopped at a stoplight. He did not have his lights on. And then, no indication that I'd done anything wrong. So I've got a tape of the supposed before the infraction and during the infraction. And
well, in Texas, they're not infractions, they're offenses, which is just a fancy way of saying a criminal penalty for a civil act. But go ahead.
Well, the reason why I was going slow, I have a legitimate argument. There were orange construction cones all around. And
okay, wait. You still have not answered my question, which is...
Oh, I'm sorry.
What in that video proves your side of the story that they had no basis for stopping you?
I was not exceeding the speed limit.
Okay. And the video on the cop car generally tells you what the speed of the cruiser itself actually is. What is it?
Oh, I didn't see that. I was just basing it upon how far I traveled.
Well, don't base it upon how far you travel. That requires calculations, which most people aren't going to be able to do or understand. Every police car's video, almost without fail, shows what the speed of the police car is in the video frame. It'll be the number that's changing constantly, going up and down as the car accelerates and decelerates. And if you actually were going 20 miles an hour and they stayed the same distance behind you in that video, then that should be the number that you're looking for on that screen, or something really close.
I don't have it in front of me right now, So I can't answer that question.
Okay, well, that's what you need to go back and be looking for. Okay, you need to identify what each of those numbers on that screen are, because that's information that's going to play a part in what they use against you in court. See, the thing is, if you, in that condition, you may or may not fully realize how fast you're going or not how fast you're going. You may not. I mean, there's been times that I've talked to people, they thought they were going 100 miles an hour, and they were moving in slow motion. And it affects everyone differently, okay? No matter what you think, it does. Sometimes 0.06 is enough. You're not legally drunk, but you're wasted off your behind regardless. So it just changes.
Okay.
So you need to be looking at that video, because that video is what's going to say whether or not you are correct. And that video is what's going to show whether or not they're lying about their initial reasonable suspicion or probable cause. So pay real close attention to that. Okay? Because in order to beat the DUI, you're going to have to beat the original basis of the stop.
Okay. So once they got that blood test, they basically have got me.
Did they get a warrant for the blood?
Yes, they did.
Okay. And how did they get the warrant?
What it was is, though, I was trying to ask them. For one, they brought me over to the police station, and they said that we're going to take a blood sample, and I wanted to read the documents prior to them taking a blood sample. So they basically told me that was a refusal. So they went out and got a judge to sign a warrant.
Okay. Did they do a field sobriety test?
Yes, they did, and it was 20 degrees outside.
Okay, wait. Okay. Why did you take it?
Stupidity.
Ding, ding, ding. Uno, Yahtzee. There you go.
I did not know that I did not have to do that. The officer was doing these circus tricks that I can't do.
Well, of course he was, because every one of those sobriety tests are absolutely subjective. The cop can make the outcome anything he wants. He can say anything in the world that you're under the influence. It's exactly the reason you don't take the test without your counsel being present. Folks, if you've been stopped and accused of a DUI, before you get stopped, understand this little scenario right here. Remember the 3 rules of every traffic stop. Shut up, keep shutting up, and shut the hell up some more. Follow what is in the transportation script to protect your rights, and do not speak any more than you have to about anything, period. The other thing is you have the right in such an encounter, before you answer any questions, take any test, perform any acts, to assistance of counsel. Never, ever refuse to cooperate. However, invoke your right to counsel prior to providing your cooperation. You get it? You want me to take a field sobriety test? Okay, fine. I need to contact my lawyer and get legal advice on whether or not I should do that. You want to draw blood? Well, I'm not refusing, but I have the right to assist the counsel to advise me on what I should do about that. And that's all you do. You never refuse. You ask for assistance of counsel. Then you call somebody that's going to be sound asleep, whether they're a lawyer or not, act like they're your lawyer, and go sleep it off in your cell until your legal counsel shows up, which they never will. Because once you invoke your right to counsel, they must stop everything except for attempting to get a warrant. And then they have to justify getting that warrant. The less you have said, the better your chances of challenging that warrant at trial or any hearing prior to trial. Okay?
A friend referred me to you, and I wish I would have heard this prior to this a long time ago.
Well, you and several million other people today, but hang on a second, Mark, and we will talk about this some more after this top of the hour break, okay?
Okay.
All right, folks, this is Rule of Law Radio's Monday Night Show with your host, Eddie Craig. We are about to take our top of the hour break, which gives us 4 more segments to handle the callers we got. So y'all hang in there, listen in, and see what we can teach and learn. We'll be right back after this break.
It's all according to the will of the Almighty. I read His There's none for the unsightly. These warmongers come by that term rightly.
All right, folks, we are back. Call-in number 512-646-1984. We have 4 segments to go in this last hour, so let's see what we can get done. We are still talking with Mark in Texas. All right, Mark, what else you got?
What is going to be the easiest way for me to get out of this, or am I going to...
Well, without seeing what information and evidence you've got on hand, one way or the other, I cannot answer that. If it shows in the video that there was no reasonable suspicion or probable cause flags that would have given them the basis they needed to make that stop, then that would be it. But you most likely will not recognize them for what they are. Let's say, for instance, the cops had used the excuse, we couldn't read your license plate light when you went by, so we assumed it was out and we stopped to check. Well, Texas requires that light only be visible from 50 feet. That's the maximum distance it has to be visible. At that point, the cops would have to prove that the light was not visible when they were within 50 feet. Okay, if they initiated the lights on their car 100 feet behind you and never got any closer than that and used that as the basis of the stop's illegal. Okay, if they come up and tell you that you're speeding, but their video clearly shows that the speed limit posted there is 35 and you're doing 25, that's obviously a false stop. There's no grounds for it, which means the evidence has to be thrown out because the seizure was illegal. You follow?
Yes, I do.
But an attorney is the only, unfortunately, in your particular case, is going to be the only one that's going to be able to take that information and put it to any use for you.
That's what I thought.
Well, the problem is you don't know enough from the way you're talking to me right now and the way you're talking about the incident. You would never survive going to court on your own. They would have you hung 5 minutes after you open your mouth the first time.
Okay, that's exactly what I wanted to hear because I needed to. My attorney wants more money to prepare for it.
Always. They always want more money. What you better be doing is watching your back with this attorney. I don't care who it is. Make your attorney understand one thing about him acting as your counsel. He is to protect your rights to the fullest extent possible and never waive any of them. Now, if he's done anything for you already, odds are he's waived a bunch of them without your even knowing it.
Like what? Can you give me an example?
Your right to notice, for example. Did he enter a plea for you without ever seeing a complaint, without ever seeing a charging instrument? If he did, he waived your right to challenge jurisdiction at a personal basis. He made a general appearance on your behalf. He entered a plea without knowing what the charges were he was pleading to, et cetera, et cetera.
Oh, he hasn't even entered the plea. It's over a year later, and we hadn't even entered a plea.
Okay, well, that may be fine. Ask him what he's done so far. What has he agreed to? What has he not agreed to? What has he filed? What have they filed? Get all that information and look at it. It's not going to be something you're going to understand up front, but if you talk to him about it, maybe he'll take the time to explain it to you. Don't hold your breath on that one, though. But at least you'll have something to learn from in your hands. Because remember, his case file isn't his. It's yours. Every piece of paper that attorney has for your case belongs to you. You bought and paid for it the moment you hired him. That's your work product, not his.
Okay.
So if you want a copy of it, he dang well better be giving it to you.
I mean, it's in Dallas County Court. I can pull it up off the...
No, stop. Listen to what I'm telling you and stop going off on your own little path here. What he has in his files may be more than what is in that court record. The evidence, the video, won't be in the court record. Any police reports won't be in the court record unless you've gone to trial or you've gone in and had an evidentiary hearing and they've been submitted as evidence already. Those will only be in his evidence file, in your case file.
Okay.
Get what your attorney has, not the court.
Main strategy of these attorneys is to delay it as long as possible. That gives them a better chance of winning it.
Or getting a deal, which throws you under the bus and lets them walk with your money.
How's that?
What do you mean, how's that? Hey, they offered that instead of a DUI, they'll call it public intoxication, give you probation for a year, and you pay this amount of money. What do you think? Oh, sure, all right, no problem. And he walks away scot-free with everything you've paid for so far.
I'm at the, when you get one of those, when you get a DWI on your record, it affects you in so many things that they're going to have to actually convict me of that.
Well,
I'm taking it to court.
No, the question is whether or not your attorney's going to take it to court. You can tell him, I'm going to trial. And then you want to know what the result is going to be when you do that? He's going to file a motion to withdraw and still keep your money. He don't want to go to trial. He wants you to pay him to do nothing. And when he files to get away from you because you're forcing him into trial, the judge is going to let him off the hook.
No, he said the whole idea is he wants to go to, the only way that I'm going to get out of it is we go to trial.
Okay.
He's already told me that.
That, again, that's not necessarily true. He can cut a deal and get you out of it, so to speak. That's what I just said. But do you have any clue how many people have told me that their attorney has told them, we're going to take this to trial if we have to. We're going to win this. And then when that day comes, they go, my attorney's trying to get out of my case. What do I do? You know how many?
Oh, I don't know. I have no.
Far more of them than stay in and finish the job. That's the point I'm trying to get you to understand here. Trusting an attorney with your life is not a good idea. You either stay on top of them or you're going to get buried by them. There are very few that live up to the reputation of serving their client. I personally have never met one. I'm not saying they don't exist, but I'm saying that them and unicorns share the same popularity in the social circles. So watch your back, legally speaking.
So should I just take a deal that the...
Whoa. No, I'm not telling you to do any such thing. I'm telling you to watch your attorney. Follow through with your attorney. Ask questions. Don't just turn around and say, here, deal with it, and let me know what happens. Because you won't like it.
Okay. I don't know. The way he's working, this could be another year and a half from now.
Well, is this misdemeanor or felony DUI?
Misdemeanor.
Okay. They've got a statute of limitations to live by here. If they haven't prosecuted the case within a certain time frame, they're dead in the water anyway. They may already be dead in the water. You said this was 2014, right?
Yeah, December 28th, 2014.
Okay, then you may be anywhere within 6 months past to 6 months until their time is out. Because it's a 2-year statute of limitations on misdemeanors in Texas. I'm assuming this was Texas?
Yes, it was. It was Carrollton.
Okay. All right. Anyway, that's where you're at the moment. I need to get to these other callers because I'm running out of time. But do you understand what I'm telling you here?
Yes, I do.
Okay.
When's your class?
Sundays, 2 to 5, Brave New Books, 1904 Guadalupe Street, Austin, Texas.
Okay. I'm gonna probably drop by Sunday.
Okay. That'll be fine.
All right. Thank you, sir.
You're welcome. All right. Now we're going to go to Charles in Texas. Charles, what can we do for you?
Hey, Eddie. Hope you had a great birthday.
Well, thank you.
Basically, I had a judge up here enter a plea on my behalf of no contest when I challenged the jurisdiction of the court.
Whoa. The judge entered a plea of no contest?
That's correct.
The judge entered a plea of no contest?
Yes, sir.
For what type of case?
Traffic violations, expired registration, and failure to maintain.
Okay. File judicial conduct complaints, file a motion to disqualify this judge, and then move to get this judge removed from his position permanently. He cannot enter. Wait a minute. He cannot enter any plea on your behalf except not guilty. A no contest plea is a plea of guilty. He cannot enter that without your consent.
Well, I did file the motion to disqualify. I filed the motion to vacate her ruling and a motion to withdraw the plea.
Okay. File the judicial conduct complaints. Is this woman actually an attorney?
As far as I know, no. She's just a municipal court judge.
Well, is it a court of record?
No, sir.
Okay. Then she could be or she may not be. In either case, she shouldn't be there. That was absolutely illegal on her behalf. You need to file judicial conduct complaints and make sure that you get a copy of that plea entered by her, get the written plea order that she put in, attach that to your complaint, and demand sanctions and removal. And then I would do a public information request and demand that they produce copies of any other pleas that she entered on behalf of a defendant that were not guilty, that were anything other than not guilty. Make them supply you with that. That will be a nail in her coffin for everyone she did. Job-wise, that is.
I mean, because, well, there's also a thing. I want to see what I might be able to do with the aftermath, like the surcharges that were coming my way.
Well, the thing is, her plea was absolutely illegal, and if she's shown this to be a pattern of abuse in her office, every case they've had is going to wind up having to be retried and thrown out. Hang on just a second, Charles. We'll be right back. All right, folks, y'all hold on. We're about to return after the break.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me. Well, ain't gonna fool me with that same old trick again. I was blindsided, but now I can see your plan. You put the fear in my pocket.
All right, folks, we are back. This is Rule of Law Radio, and we are speaking with Charles in Texas. All right, Charles, please continue.
Well, anyway, what I'm worried about more on the surcharges. So, I mean, when I do the disqualification for the...
Well, here's the deal. What happens in Texas is absolutely unconstitutional on its face, the way they've got it set up. 30 days after your case is filed in the court is going to notify DPS of the case, whether it's been heard or not. And DPS is going to go through the process of assessing surcharges, whether you've been convicted or not. Then you have to jump through hoops with them to get that removed for the whole thing. It's absolutely unconstitutional and ridiculous that this is allowed to operate this way. But that's what's going to happen. So when you get that notice from DPS, you need to send a letter of protest and a tort letter if they implement.
Okay, no problem. Okay, that's all I need to know, because I've already proceeded against her on one front. I won't proceed against them against the other front. Because that's basically what it is right now, the war for our freedom. So that's what I'm doing, is fighting for mine now.
Well, I wish you luck and stick with it.
Yes, sir. Thank you, and I hope everybody else has a good night.
All right, Charles. Thanks for calling in, man.
Yes, sir.
All right, now we're going to go to Ernest in Texas. If I can get to this. Ernest, what are we going to do for you?
Hey, Eddie. How you doing tonight?
I'm doing all right so far.
Awesome. Hey, we had a few email exchanges back and forth, I think, 3 or 4 months ago, something like that.
Okay.
And basically there's been a few new developments since then, and I thought I just had to get on here so I could chat with you about it.
All right. Refresh everyone's memory. What are we talking about?
Okay, so in about a year ago, or almost a year ago, I received a citation from a police officer who claimed I was speeding down a road that was riddled with potholes, and actually still is. I mean, I actually went down that road the other day and tried to get above 30 and couldn't even make it. I was afraid I'd knock a wheel off my car. And also, there's absolutely no lighting, no visible lighting. So anyway, I received a citation for speeding. I think he said I was going 46, if I'm not mistaken, which is pretty fast down that street. I challenged it. This particular officer was on the news because he struck a pedestrian with his vehicle. He hit a pedestrian who was walking across the street and caused him brain damage. And so he was on the news for that. And I requested those records. And the reason I did was through discovery. And the reason I requested those was because I wanted to find out if he can can't see a 200-pound man walking across the street. And they basically blamed it on a poor lighting situation. How do they expect me to see a 15-pound sign sitting on the side of the road with my lights are shining forward? And so basically that's basically what I was kind of angling at when I requested those records.
Have you filed anything in your case?
I'm sorry?
Have you filed any documents in your case?
I have filed a motion for discovery, and I have filed a motion to quash.
And this was a traffic ticket, right?
Yes.
Okay. And
so...
Go ahead.
So we were shortly after that. I was playing basketball. After I filed the documents, I was playing basketball at my local park here, and I fell and I twisted my knee and I couldn't get up. So I told my brother-in-law, "Bring your car up here so I can get in the car so I can go elevate my leg." Well, as soon as he brings his car up, here comes this same officer asking what we're doing. You can't park your car there. You're going to get a ticket. Basically just giving us a hard time, almost as if he was waiting for an opportunity, and he saw one. And then shortly after that, he pulled me over again and gave me a ticket for speeding and no insurance, which I showed him insurance on the vehicle I was driving, which had the owner's name. It was a valid insurance. I was just borrowing a truck because I needed to put my daughter's bed in the back of the truck. And I showed him insurance that the vehicle was insured, and then also told him I had permissive use insurance on myself, where my insurance covers me no matter what vehicle I'm driving. He still gave me a ticket for no insurance. And so here I am. So now I'm fighting 2 speeding tickets. And I was fighting 2 insurance tickets because the first time he gave me a ticket for no insurance as well, but that one got dropped when I showed insurance. The second one did not get dropped because they said my name, that truck has to be insured under my name.
No, that's a lie. That's an absolute lie.
Okay.
The insurance is not it. The insurance is for the car, not the individual. That's why it's called an automobile policy and not a driver policy. It's only a driver policy when you're commercial and you operate in different vehicles.
Okay.
So
I guess am I able to file a suit against him for giving me?
Okay, here's your situation, and this is what I've been talking about with folks on this. One, do you have the transportation seminar, the rule of law traffic seminar?
No, not yet.
There's problem number 1. Problem number 2, you also don't have the constitutional challenge motion. You don't need both of them, but you need one of them. Okay?
Okay.
The constitutional challenge motion shoots every one of these right between the eyes because every one of these comes from the transportation code. And the transportation code as it exists in Texas is 100% bona fide unconstitutional under the Texas Constitution. The whole thing. Okay. Not parts of it, not certain pages or paragraphs, the whole thing.
Okay.
All right? So that's one thing you can do to file and get rid of everything because they're not going to have any answer to that motion. I guarantee you they're not going to have. At least not one that will be based upon any facts they can support.
And that's a constitutional motion you're talking
Correct.
about. Correct. Okay.
The only way any court in this entire state is going to defeat my constitutional challenge motion is to declare either A, the Texas Constitution doesn't apply to anyone anywhere in Texas ever again, or B, that the Texas Constitution doesn't actually say what it says.
Okay. So I need to get online and purchase that?
That you won't get online. You can do a donation to me online, and then that money will get, and remember that the price on it changed, okay? It changed on February 29th. It was $100. Now it's $150. Deborah gets 50 of that for the fundraiser. The fundraiser hadn't gone as well as we needed it to, so I agreed to help her raise some extra money by going up on the motion. So sorry, but it's $150 now.
Okay. And let me ask you, how long does it take to fill out everything and then file it? I mean, what is the?
You have to read it. It's 70 pages long. You've got to read it. You take out the parts that are everything in it is color coded. You're going to get about a dozen or so documents, 4 motions, an affidavit, and supporting documentation and instructions. Okay. So you've got to edit each of those documents, which everything that you've got to edit is highlighted in some color fashion to tell you what to do with it. The instruction document tells you what to do with it. Follow that, get it done, and you're golden. Okay?
Okay. And let me ask you one question that I did have is it possible to also sue the officer for giving me a ticket for no insurance, even though I showed him?
If you can show how that caused you a harm, yes. If they don't prosecute you on that, then what you're going to have to do is press criminal charges, but you won't be able to sue. If they actually drop that charge, even though he lied, then you didn't get harmed, per se, is the way they're going to look at it. But he committed a felony by falsifying a government document, and you have evidence that he did so. That's a whole other animal for him to have to face. Hang on, and we'll pick this up on the other side. All right, folks, Rule of Law Radio. We'll be right back with half an hour left.
Reality TV, sugar, obesity, jet lag. The list of things that makes us dumber just keeps on growing. But now researchers say we can add stress to the list. I'm Dr. Catherine Albrecht, back with details in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Are you always on the go and juggling multiple projects? If so, you might think that multitasking proves you're smart. But think again, all that stress might be eating your brain. A new study finds stress reduces the number of connections between neurons, which actually makes it harder for people to manage problems. Researchers at Yale University found that stressed out people have less gray matter in their prefrontal cortex. That's the part of the brain that helps us weigh conflicting ideas and regulate our emotions. So take a deep breath and chill out. It'll help keep your mind as sharp as a tack. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
USA.org.
You're listening to the Logos Radio Network at logosradionetwork.com.
Yeah, and who you want to chip? Who you take me for? Free Tolly? Who you want chip? Me no free Tolly. You can't chip me. All I'm saying. Don't let them chip you in the morning, chip you in the evening, put a chip in your body. And anyway you go computer ready, you can't hide me from nobody. When me say, chip in your mom, chip in your daddy, chip in your grandpa and the grandme.
All right, folks, we are back.
Chip in your family, whole family. Chip in your dog and they kept around we. Chip in the beef and you still go eat it. Chip in the fish.
Sorry, I got a very touchy mouse here and I hit the wrong button that time, but let's figure this out and get back in line here. All right, now we're going back to Ernest. All right, Ernest, anything else before I move to the next one?
Well, one other question that I had about the constitutional challenge was that should work for both the citation for no insurance.
It will work for anything that comes under the transportation code.
Okay, I think that's it then.
Okay. All right, man.
Thank you very much, Eddie. I appreciate your time.
Hey, no problem. You have a good night and good luck.
All right. Thank you very much.
You're welcome. All right. Now we've got Ted in Washington. Ted, what can we do for you?
Good evening, Eddie. Thank you for taking my call.
Sure.
All right. So I went to court today for a situation, and I'm wondering how to go about subpoenaing information about a court watcher.
Whoa. Wait. Say that again now?
I have a strong suspicion a court watcher in the audience was in cahoots with the prosecuting attorney.
In what way?
Well, only because in the lobby, I happened to just go up to anybody that was standing there to ask them a question as to where the bailiff was. And this guy had a very rigid body language and demeanor, and he used my own line against me, the very same line that I used when I got pulled over on the side of the road, which was, I do not answer questions. I asked him, I said, excuse me, do you know if the bailiff is in there? And he said, I do not answer questions. So right away I realized it is close to impossible, highly unlikely that just somebody at random would use the very same line verbatim against me.
Wait. And wait.
Go ahead.
You mean that you find it hard to believe that someone that may have seen a video on YouTube that's got X million hits would be using the line that's in the video?
Well, no, I didn't think about it that way. I mean,
well, maybe not, but you're using it. Where'd you get it?
Well, correct. No, I got it from a mentor like yourself.
Okay.
But this particular person was extremely rigid, and his body language, I could tell that he had no business being there. So, sure enough, at the end of the trial, I went through my whole procedure, and he and the prosecuting attorney walked out to his truck. They were talking together. She almost got into his truck, and he waited for me to be the very last case to be tried for the day before he left. So all my evidence, all my suspicion, my clues are coming together that he is working either with her or for her or helping her out. Hey, no problem, but I almost want to file an affidavit or even a subpoena to get information against him.
Well, one, you don't know who he is, right?
Not yet, but that's what I intend to find out.
Well, okay, but here's my part about you doing that. Is it illegal to court watching where you are?
No, of course not. I had a court watcher of my own.
Okay, it's a public courtroom, right?
Well, yes, of course.
Okay. Did he send any signals to the prosecutor? Did he go up and whisper in her ear while you were in there? Did he peek over your shoulder and read your documents and then pass notes to her? Anything like that?
No, none of that. None of that, but they were the very last ones to walk out. They walked out together. She almost got into his truck. So at this point, I almost wanted to...
Okay, who did your court watcher ride home with? Who did your court watcher ride home with?
With me.
Okay, who did you talk to on the way out of the building or outside?
Nobody else.
Okay. The part I'm trying to get you to look at here is, why are you thinking if none of this stuff I mentioned occurred, what is the issue here?
Because he used my own line against me.
Okay, still not drawing the picture that I'm going to see an issue here. This very well could have been a police officer. It very well could have been someone in the office where the prosecutor worked who was familiar with the facts of the case. Wait a minute. Familiar with the facts of the case. Saw the police report. Any number of things. He may know who you are. He may have looked up your information based upon the police report. It wouldn't matter. The problem here is if he's somebody that had a legal, reasonable basis for knowing that information, and the only place you saw them was in court, and they didn't say or do anything that would make you fearful for your safety, or to testify on your own behalf, or to present evidence on your own behalf, or undermine your defense with the prosecution by stealing your records and giving them to them, I'm not following your problem here. Other than potential paranoia, but...
No, it's not paranoia, but I did not just see him in the courtroom. He made a point to watch me as I walked to my car. And they stayed there together, side by side, chatting, looking directly at my car. And I made it a point for them to see me wave at them as, a little have a good day, and I'll see you later on next month.
Okay.
So I highly suspect that they're together. And
okay, well, let me ask this question. And since we're not getting beyond that point, let me try this. Who are you going to ask to give you information about the person in the court?
I don't know yet. That's why I'm calling. What I also want to do is use it as intimidation towards the prosecuting attorney. Because
whoa, wait. Okay. Open mouth, remove foot. You attempt to intimidate a prosecuting attorney, you will get a lot more than a traffic fine. Are we clear on this?
Clear.
Good, because that's going to be the end result if you pull something like that. Guaranteed.
Fine, maybe let's not intimidate her, but let's just make her know that I want information about him since I've seen them together.
Again, she's not under any obligation to provide you about information from somebody from the public gallery. None. You're not going to make her provide you with anything. For all you know, he's a witness that she intended to call, if it was necessary.
Well, right. She didn't disclose that on the Brady request, on the information request.
Did you request a list of state's witnesses?
Yes, I did. Correct.
Okay. Then if you don't know if this guy is one of those witnesses, or unless there's only one on the list and you know for a fact this isn't him, what's the problem?
Correct. I do, for sure.
Okay. Well, then that was just a suggestion, not a fact. I don't know if it's going to be a witness or not. I was just trying to offer up potential reasons for him being there. Like I said, it could be a fellow prosecutor from the same office. It could be her husband, her boyfriend, somebody that she's discussed at least some part of her case with. Now, that's a completely different issue that you may be able to burn her with later, but it isn't going to help you right now.
That's what I'm trying to obtain, some help to find information about him.
Well, the problem here is I can't give you any because no one is under an obligation to tell you who is watching a court appearance. No one is going to know unless they already personally know the person, and they're still not going to be obligated to tell you.
Okay, sure. I mean, that's understandable. Then maybe I could file an affidavit of fear against my safety because he was...
Okay, wait.
watching me get in.
Wait. An affidavit of what?
An affidavit of fear.
Okay. Can I ask you something about affidavits that you obviously feel they have a power that I have yet to find, but enlighten me a little bit here? Just exactly what would you accomplish by writing an affidavit titled Affidavit of Fear? What would you do with it?
Get it into the record and make it...
Whoa. Whoa. Let's take this one step at a time. Let's begin with get it into the record. In what way is this affidavit relevant to the actual facts of your case? Think about that for a minute while we take this break and fill me in on the other side. All right, folks, this is Rule of Law Radio. We've got one segment left. Guys, Matt, Holly, Sally, y'all hang on there. I will try to get through this and get to you, so please don't just hang up and go away. I'll do my best. Y'all hang in there and let's see if I'm successful. We'll be right back, folks.
Easy.
All right, folks, we are back. This is Rule of Law Radio. We are now in the last segment of the show. We are talking to Ted in Washington. Ted, hang on one second, and let me remind everybody where we're at. Ted wants to do an affidavit of fear and get it put into the record for his case. And my question before we went to break was, how is such an affidavit relevant to the facts of his case specifically? All right, Ted, go ahead.
At this point, Eddie, I apologize. I've got nothing.
Okay, and that's because there is nothing. That's because it doesn't. It won't. It can't. Wait a minute. Listen to me. It has nothing to do with the facts of the case before the court. So there's two problems with doing an affidavit of this sort. One, it's completely irrelevant. Two, it's not evidence of anything whatsoever until somebody takes the stand and testifies to it in order to introduce it as evidence, and that can only be you. But again, we have to skip B and go back to A. You're not going to be allowed to testify to it because it's not relevant. Your personal feelings, short of proof that this individual was attempting to intimidate you in relation to this case, is moot. If you can't prove that, you've got no argument.
Correct. No, I can't prove that. I was just hoping to make it known to her that I realized that he was watching me also on her.
Well, you can say that all day long. I suspect that this individual is working with you in some way to surveil me or to, something on your behalf, and I feel like I'm being intimidated. Now, watch her eyes get wide when you say that to her, but that's not you trying to intimidate her. That's not you trying to sway her. That's you communicating to the other side. I believe you're being underhanded.
That's what indirectly with your education I was trying to get at. If there's anything I could do, and I guess
well, but that's not the question you were asking. You wanted to know who the guy was.
No, it wasn't.
Well, that may not tell you who he is. Okay, but the point is,
right.
That's about the only way you're going to get away with doing any of this.
I understand. It makes sense to me, sir.
Okay. Well, good luck then.
All right. Thanks so much.
All right. Take care. All right, now we've got Sally in Texas. If that blame screen will stay where I put it here. Sally in Texas. What can we do for you?
Hello, Eddie. You can keep being peaceful like you always are.
I'm sorry. What was that last part? You're breaking up a little bit.
You can keep being wonderful.
Oh, okay. Well, thank you. I don't get that word associated with me very often, but thank you.
Well, I want to remind everyone to click on the Amazon banner on the Rule of Law Radio every time before you shop and dig deep and donate for Eddie's cause, because all of us would be up at Lincoln Creek without a paddle without all of his knowledge and work. So it's just a reminder for everybody to get busy and support you.
Well, thank you. That would be good. Sometimes it gets lonely up here going, you know what? I can't figure out why I get all these emails, but no help.
Yeah. And it's about time for all of us to be helping more. And every time you think you've helped all you can, get off your butt and help some more.
Well, thank you very much, Sally. I appreciate that.
Thanks. We'll be doing more can too. So.
All right. Well, thank you very much. Appreciate it.
All right. Bye.
Bye-bye. All right. Now we have Matt in Pennsylvania. Matt, what do you got?
Eddie, I'll make it first time caller. Listened a few times. I'll make it brief. The officer passed away in my DUI case.
Okay, not laughing at that tragic side of his family's loss, but what a way to win. I know most people are always wishing the cop that did this to me would just up and die, and you actually rolled into that one. All right.
My brief question, setting aside, he was a good guy, and I, attracted his attention. Can they proceed with just evidence of video without the officer's testimony?
Absolutely not. The only way they could do anything in this instance now is if he actually did a recorded deposition and the court allowed that to be testimony. But the problem there would still result in the fact that there's no one to cross-examine. You cannot cross-examine a deposition. You cannot cross-examine a video. And there's no one but the officer to testify to what that video is and what happened at that scene, right?
Well, somebody called at a convenience store and alerted them of my presence.
Okay. Presence at the convenience store?
Yes. Apparently I was off balance a little bit.
Okay. Well, when they alerted them to your presence, what did this other person actually see? Now, again, when you said video, I'm assuming we were talking about video from a police car. If we're talking about video from some building's security camera, that would be a whole other matter if there were multiple witnesses available for what was occurring on camera there. Now, if this was a stop on the side of the road out in the middle of BFE with the cop in his car, they're stuck. But now if the other's the situation, well, that's a different can of worms.
Yes. So a motion could be made to dismiss for lack of prosecution, but it may not stick if there are other witnesses that
Well, in order to get a motion for lack of prosecution granted, you've got to be beyond the statute of limitations or the limitation on time to initiate that prosecution. For instance, here in Texas, a Class C felony misdemeanor, they don't have forever to prosecute the case. They've got 2 years to file the complaint, but once that complaint is filed, the speedy trial clock starts ticking. They must prosecute that case in less than 4 months, or the Texas courts have ruled you didn't get a speedy trial in that case, and you should have. So,
all right, then maybe I'm looking at a suppression hearing or a motion to suppress evidence.
Well, again, in order to suppress the evidence, you're going to have to show the evidence was illegally obtained, or was somehow tampered with, or was somehow not provided through discovery, but now they want to use it against you. That's the way you're going to get motions, your evidence suppressed. You're not going to get it suppressed just because you want it suppressed.
I need to make a formal request for discovery or have my public defender do that, because an informal request has been made, but I haven't been able to view the video.
Has your attorney?
He's a public defender, and I haven't discussed that with him. He's encouraging me to plead.
Well, of course he is. That's why he's a public defender.
Well, I understand. But before I fire him, if there's a frictionless way to utilize him, I would like to do that.
Well, the thing is, you can tell him what you want him to do. That doesn't mean he's going to do it. You cannot file the motion if he's working for you. They will never let you file anything if you have representation with an attorney.
All right. Well, I gave him a motion to strike and dismiss the complaint based on no case, crime or cause of action and no corpus delicti, and he still hasn't filed it.
Exactly. And he won't.
Well, it sounds like I will file it because I'm filing it against the Commonwealth of Pennsylvania and Officer Jason E. Sapp, who is deceased.
Okay, well, again, if he's not the only witness, that's not going to matter. The only thing he would be called to testify to is what information he personally is aware of. And since he can't do that, they will use any other witnesses that were there. If they know and have the person that called in. Now, here's the other thing. The person said, I'm assuming, that they saw you arrive in a car and that you appeared to be this, that, or the other. At what point did that person come in direct contact with you? At what distance? For how long? What did they hear? What did you say? How did you smell? How did you look? Those are the kind of things they're going to ask you. Did they observe you walking any distance or any acts that you may have done that seemed impaired? Now, when they use a word like seemed or appeared to be, they're asking for an opinion. That has to be objected to. They can only ask things because what they're doing there is they're asking leading questions and they're putting words in the witness's mouth. That has to be objected to. All they can say is, can you please tell us what you observed the defendant doing for the time they were at the store? And then they've got to tell them on their own. But if they tell something that can be shown to be incriminating and the video supports it, they've got what they need.
Even without a blood test and even without a breathalyzer.
Wait a minute. That all depends on what the jury's willing to accept as evidence. If the court says that they've got enough, they don't have to have the blood, they can. But if you can make the case without an attorney that, hey, you don't have any evidence I was impaired. You know, I took cold medicine. I didn't know it was going to affect me that way. You see what I'm saying?
Correct. Can the affidavit for probable cause be admitted at trial without the officer?
Is that officer the one that signed it?
Yes.
Then the answer there would be yes, because it's already been recorded as an official record with a stamp on it.
Gotcha. Thanks very much for your time, and I'll keep listening and attend your classes online.
All right, sir. Thanks for calling in. All right, folks, I'm sorry I was not able to get to the remainder of the callers, which I only had a couple left, thank goodness. I do apologize for running out of time. I did my best. All right, folks, this has been the Monday Night Rule of Law Radio with your host, Eddie Craig. Thank you all for listening. Please keep donating to the network and make donations for me and to the lawsuit. We need it. We'll see you next week.